For what feels like forever, the big question in crypto has been, is it a security? It's been this huge gray area. But guess what? The fog is finally starting to lift. We're talking 2025, and a real, practical playbook is actually taking shape, thanks to some huge court cases and some brand new laws. So here's what we're going to cover. We'll look at the regulatory battlefield, where all this is happening. Then we'll zoom in on the Ripple case, a total game changer. After that, we'll see what Congress has been up to with the Genius Act, and we'll wrap it all up with a modern compliance playbook that, you can actually put to work. All right, so where is all this newfound clarity even coming from? Well, it's not like one single memo dropped from the sky. Nope, it's actually being forged in two key places at once. We're talking about the courts and we're talking about Congress. And this is how it's playing out. You've got the courts, right? Landmark cases like SEC versus Ripple are basically setting the rules through legal battles. Then, on the other hand, you have Congress stepping in to write totally new laws, like the Genius Act, creating clear categories from the get-go. Two very different approaches, both leading to more clarity. Let's kick things off with what's been happening in the courtroom. Okay, when you talk about the courts, you absolutely have to talk about SEC versus Ripple. Seriously, this was the defining lawsuit for crypto in the last 5 years. It put a huge crypto, XRP, right in the hot seat to answer that billion-dollar question. Was it sold as an illegal, unregistered security? And listen, this wasn't some quick legal skirmish. This thing was a marathon. We're talking a nearly 5-year battle. It all kicked off way back in December 2020 when the SEC filed their complaint. The real bombshell dropped in July 2023 with a huge summary judgment. And after some more back and forth, the whole thing was finally settled in August of 2025. So what was the big outcome? Well, it was this fascinating split decision. The judge basically drew a line right down the middle. She said, okay, when Ripple sold XRP directly to big institutions, yeah, that looks like a securities sale. But, and this is the huge part, when regular people bought XRP on public exchanges, what the court called programmatic sales, those were not considered securities transactions. Wow, that was a massive deal, bringing a ton of clarity to how tokens trade on the open market. Okay, so that's the court side of things. Now let's pivot to that second front we talked about, Congress. Because while all this drama with XRP was unfolding, lawmakers were working on something completely different. They were creating a whole new rulebook for a specific type of crypto, payment stablecoins. And compared to that 5-year court battle, this moved at lightning speed. The Genius Act popped up in the Senate in May of 2025, and with both parties on board, which is rare, right? It flew through the Senate, then the House, and was signed into law by July. We're talking just 2 months. It was a huge signal that Washington was ready to get serious about creating clear rules. So what's the secret sauce in this law? It's something called a jurisdictional carve-out. Sounds complicated, but the idea is actually pretty simple. It basically creates a special dedicated lane just for payment stablecoins. It says, hey, these aren't securities, so the SEC doesn't regulate them. And they aren't commodities, so the CFTC is out too. It puts them in their own unique box. Super important. All right, so let's pause for a second. We've got the courts drawing lines in the sand, and we've got Congress creating entirely new categories. So what does this all mean for you? For anyone really trying to actually work in this space? Well, it means we can finally build a real modern compliance playbook. So let's do it. First things first, and this is maybe the most important mindset shift. Crypto isn't some far-off what-if scenario anymore. It's here, right now. For pretty much any financial institution, your exposure isn't a question of if, but where. It's already in your system whether you realize it or not. So, to handle this new reality, you need a solid framework. And it really boils down to 3 key steps. Step 1, assess your exposure. Step 2, vet your partners. And step 3, engage proactively. Simple, right? Let's dig into each one. Okay, step 1, assess. It's common sense, really. You can't manage a risk you don't even know you have. This means you've got to do a deep dive, a complete map of every single place your business touches the crypto world. That could be in your retail division, your wealth management, anywhere. Once you see the whole picture, then you can spot the weak points and beef up your customer due diligence. All right, quick definition before we jump to step 2, because you're going to hear this acronym a lot. VASP. It stands for Virtual Asset Service Provider. It's just the official speak for any crypto business you might be working with, exchanges, OTC desks, payment processors, that whole crowd. Okay, step 2, vet your VASPs. This is critical. All crypto partners are not created equal. You have to do your homework. Ask the tough questions. Where are they located? Are they properly licensed, say with FinCEN here in the States, or under the new MiCA rules in Europe? What assets do they even handle? And maybe most importantly, how good are their own compliance programs for things like AML and KYC? And that brings us to step 3, engage. Look, the days of regulators just shrugging their shoulders about crypto are over. They now expect you to have a plan. They want to see that you're thinking about this maturely. So that means being transparent and proactive in your conversations with them. It's not about hiding from the topic anymore. It's about showing them you've got a handle on it. All right, so let's boil this all down. What are the key takeaways from our modern compliance playbook? Let's recap. It all comes down to these 3 pillars. Number 1, assess. Find your crypto exposure because trust me, it's there. Number 2, differentiate. Know who you're dealing with. Not all partners are the same. And number 3, engage. Talking to regulators isn't optional anymore. It's smart business. You nail these 3, and you'll be navigating this space with a whole lot more confidence. Because at the end of the day, this isn't just about avoiding risk or dodging fines. A strong compliance program, that's not a defense. It's an offense. It's the foundation that lets you build the next cool thing, the next wave of innovation, safely and responsibly. So with all this new clarity, the real question is, what are you going to build?